Hello, everybody. I just want to tell you that we are waiting some more minutes to allow people to join in. So please be patient, 1 or 2 minutes. So welcome, everybody, to this year's legal workshop, which is taking place online the first time due to the COVID-19 situation we are still facing everywhere. So we don't have a face-to-face meeting, unfortunately, but we hope this series of 3 parts with legal stuff will help you and be a good kind of replacement for the legal workshop you're used to have once a year when the CSA summit is taking place. We choose to have 3 parts because we don't want to overload you with legal stuff on one online meeting. So we hope you enjoy these 3 short sessions. First of all, I'd like to start with some housekeeping. So at the end of this webinar, we'll have a Q&A session. However, please feel free to submit questions at any time. You can do so by using the chat function in your control panel. If there is an urgent question, I will give a sign to the speakers so they can wait for a minute. I will pass the question to the speaker and they can answer immediately. Questions that can wait till the end of the session, I will present at the Q&A session. We will have some interactive elements during the webinar, so I really like to encourage you to take part in our little surveys. Hopefully you will have a kind of workshop feeling by doing so. This year's motto from the CSA email summit, but also from our workshop, is bridging the gap, reality versus expectation. So we want to help you bridging the gap when it comes to your daily business, particularly when legal expectations hit the reality of email marketing and your client's view on things. As almost always, we are focusing on issues we determined last year when handling reports, but also issues that were raised during the certification process. Before starting content-wise, I'd like to introduce you to today's speakers. Those who are still aware of the invitation may see we have a little change in the staffing of today's webinar. Unfortunately, Astrid had to cancel her participation on short notice, so I'm very happy that Peter agreed to step in here this noon and will take over the presentation Astrid should have given today. Peter and Sebastian are both my colleagues from the complaints office responsible for reports handling, but also giving legal advice and legal presentations in the CSA and ECHO work sphere, so to say. I'm Alexandra, I'm the attorney and head of complaints office responsible for the legal oversight, but also for giving presentations, and in the field of the CSA work, responsible for the work with the complaints and certification committee. Today, I'm your moderator, and now I'm happy to hand over content-wise to Sebastian to start the presentation.
All right, thank you, Alexandra. Now we're going to focus on the presentation itself. All right, so it's always good to start off something that is about legal things with something that is bright and blue and nice, like this little thing here. And it's entirely not anything to do with legal stuff. It's basically statistics. I'm going to bore you with some statistics now, but what's kind of interesting, as you can see, of all the complaints that we have gotten that had a relevance to CSA or CSA senders about unwanted emails in 2019, this is what the results look like of these processes. So in 96% of the cases, the big blue one, the complaints process ended in a notification, which means that we found one or more violation of CSA criteria in that case. And the gray area, you can see that's about, I think, 3.6 cases, 3.6% of cases, sorry, that we had to issue a dismissal, which simply means that there was no violation, which is good. And then there's a little tiny chunk between them, which is 0.35%. Those are merged cases, which simply means that there was a notification issued, but it was duplicate cases, for example, or cases from the same email marketing campaign. So in total, we had 861 cases. Again, 96 something percent of which ended up showing violations of the criteria. On the next slide, we're going to see how this progressed over the years. As you can see, there's more or less a steady incline, some ups and downs, but overall, the sheer volume of emails has increased, and so have the complaints and violations, of course. Last year, you can see the chunk for technical violations, which is the gray chunk, is, well, a little bigger than in the years before, especially if you combine that with the light blue chunk, which is cases where we found both legal and technical violations. But clearly, the biggest chunk is the dark blue one combined with the light blue one, which combines all legal violations. So a little over 700 in total. Now we're going to go to our first poll, first interactive little session with you, and I invite you to join us for that. As you can see, we had about, or as I said, we had around 860 complaints cases in total last year, which were related to the CSA. But as many of you might know, the ECHO Complaints Office doesn't only handle CSA-related cases, but we receive complaints about unwanted email or spam email from all senders, or even not CSA-related ones. And so we just thought it would be fun, actually, to maybe guess how many complaints do we get about unwanted emails. So we have a first survey prepared, and it's already ongoing. I can't see it, sorry. So as you can see, there's 3 options to choose from, and I invite you to try and guess which one's the correct number of things that we received. And results are coming in. I'm looking at Alex. So, okay, we're still giving it a second, or are we done? No, we're giving it a second, okay. we don't have a nice jingle for you. I'm sorry. I'm not going to sing. I'm not going to do that to you. All right. Okay, so since I can't really see the results, I'm going to ask Alex to jump in and tell us what the results are. What do the people think?
Okay, we have a result of about 70% who took part. Thanks for that. So 52% think it's 284,149 is the right number, followed by the second option we offered 106,548, and 40% are going for the 90,000 something figures. So Sebastian, it's up to you to give the right answer.
All right, so thanks for participating, and the 52% were right. It's the highest number, of course. We get a lot of complaints about spam emails, and from that you can see that the CSA relevant ones are really just a fraction at this point. All right, so thanks for that. And now, as I said, the highest percentage of the violations that we actually see are legal ones, and we're going to go a little more into detail about those. So last year, as you know, any notification or any case can issue or can feature more than one legal violation, of course. But and we're going to start here with the biggest chunk, 46%. In 46% of the cases, or 46% of the legal violations that we saw, were due to insufficient permission data. So we didn't get any or enough proof of consent or customer relationship, which is permission. Then the next chunk is about a quarter, had to do with consent, some 24%, yes. So anything around consent, we're going to go deeper into that next week. Just to complete this, we have still a big chunk, 16% of the reasons were violations of the criteria concerning the imprint information, so the legal notice or footer in the email. We're going to go into that in week 3. And then we still have a not very tiny chunk for the opt-out notices. That was a problem in 10% of the violation cases. And then there's the rest, as always. So we're going to take this as some sort of a roadmap for these workshops to dive into the points that were the biggest problems, starting off with the biggest one, insufficient permission data, which has everything to do with documentation. And this is where I hand over to my colleague Peter, who's going to give you the rundown for that.
Oh, yes, thank you. So, as Sebastian said, the main topic of the legal violations were the insufficient permission data, or that the sufficient data is missing, basically. So, for instance, what we often have in the feedback when we ask for permission data is that we just receive back like it was collected in 2020, like just a year, or November 2020, or the location is missing, where people are or your clients are not able to tell us where the customer or user apparently opted in. So to be able to prove the permission, one has to show when and where the user has done what exactly, to put it bluntly. So the text of the permission at the time of the collection is also relevant. So the permission can be in the form of the statement of consent, or in the form of the so-called exception of the existing customer's relationship. So why is missing documentation a problem? So concerning the consent, the GDPR demands in Article 7, paragraph 1 that the controller shall be able to demonstrate that the data subject has consented to processing. And concerning the customer's relationship, Article 13, paragraph 2 of the Data Protection Directive for Electronic Communication, or as we love it in short, the e-Privacy Directive, and of course the national implementations of that, demand that proof is necessary. So in both cases, the burden of proof is necessary on the sender. So the sender has to prove that. So what happens if those legal rules are violated and there is no documentation, or the documentation is not correct or incomplete? Well, basically, it could be fines given by the national data protection authorities. It could be a lawsuit by the complainant or the user himself. And of course, for CSA participants, a procedure at the complaints office can take place, and sanctions could be the consequences. So during the last 2 years, the fines have increased in all European countries, and the highest amounts have been several hundred million euro. So when there is a procedure at the complaints office, the consequences can be, in the worst case scenario, a permanent delisting from the whitelist. And so, yeah. So how to document the given content? So what has to be documented to prove that the content is given? So this depends on the kind of permission. If you base the sending on consent, it would be Article 7 on the GDPR, or if you base it on the exception, as I said before, it would be Article 13 of the e-privacy directive and the corresponding national implementations. So senders of commercial emails must be able to show and prove, of course, that they have received consent to use an email address and that the consent was given by the actual owner of that said address. The only safe way to prove that the owner of an address actually has consented in a way which is accepted by the courts, which is kind of relevant, is the double opt-in or DOI at the moment. And for that, I will hand over to Sebastian, who will lead you through the permission of consent with the aid of the double opt-in email.
Okay, all right. So as Peter just said, the double opt-in process or DOI process is not actually, defined by law or wanted by the law, but factually it is mandatory because, as Peter said, it's a common and, by some courts' opinions, the only way to really prove consent. In any case, we're going to take the double opt-in process and especially what needs to be included in such a DOI email message as the forum, basically to show you what needs to be documented in every case. So first of all, very basic information like date, time, and source. Where was the email address collected, or where was the consent given technically, when and where. Where is usually a website. I know of cases where it's offline, but of course the standard is online data collection. Then the text of the declaration of consent. We've put that here in under the DOI email, but this is more of a general rule. You need to prove what has been consented to, and to do that you need the text of the actual consent declaration. The next is more to the point of the DOI email itself. Oh, I think we have a question here at this point. So Alexandra.
Yes, there's a question, and I think it's good to put it here. So the question is, hello, what do you mean exactly by source? URL, name of the website, enough IP address, user, all that stuff. So
okay, so pertaining to online data collection, of course, that would be basically the website. Yes, URL, website. I'm not a technician. For me, that's the same thing, but I know it's not. If you can point me, for example, in a CSA complaints case, if you can point me to a website where I see an online form, and there I see the declaration of consent, then that's the source in that case. Of course, IP addresses, that would not necessarily mean anything. Just the IP of the website doesn't make any sense. The IP of the person giving consent is nice to have, but not necessarily needed to prove consent. So yes, by source we mean where was the consent given? Where is the little check mark that somebody said, yes, I want emails? This is what we mean by source. All right, I hope I answered the question. Otherwise, just put another one inside the chat box. Thanks. All right, thank you very much. Where were we? Confirmation request. Okay, so this is what we've talked about so far is general documentation basis or basics for for consent documentation. And since we're talking about it in the context of the double opt-in email, we would always recommend putting in, or that's good practice, put in a confirmation request, something like, did you really enter your email address? If you want to confirm that, press this link or send an email back. It's basically a call to action to the person signing up. So what I want to stress though, and this is the last point on this, no commercial content should be within the DOI email. Why is that? It's simply technically, on a technical note, the DOI email is nothing but a verification of the owner of the email address. So if I enter Peter's email address in some online form and he gets a DOI email and there's commercial content in there, then he just received some commercial content without giving consent. If he just received the DOI email without any commercial content in there, then this is just the bare minimum that the person that is receiving the consent has to do to make sure that it's actually Peter's email address, or my email address in that case, which is not. So yes, again, to store the information that is in the DOI email, if it's all that, it can be much less than that, but if it's all that, that would be one way to prove the consent, if then the confirmation request has actually been used by the receiver of that email. So all right, we have a little example here, an example DOI email showing all these things. This is a bit much of text, don't read all that. It's just to show you how that would look in the real world, and we can go paragraph by paragraph basically and see what information is there. So in the first paragraph, this is where we have what we call date, time, and source. So you see an URL there, and there's your answer for the question that we just had. Where was the email, or where was the consent given? And okay, we didn't put a date and time in here because this is a template, but this information would be there in a real one. And then we have more or less the text of the declaration of consent, not completely as you can see, but it is still in the first paragraph, some sort of a short version of it. It says you consented to receiving this newsletter. All right, so then in the next paragraph, we have the call to action that we talked about. This is not legally necessary in this case, but technically necessary for the DOI functionality. Again, important, there's no advertising in this email. You can always, of course, put your logo in there, put your name in there. The person receiving this needs to know where this is coming from. This is not considered advertising, but we didn't, for example, put any products in the footer of this. That would be advertising and bad, yes. All right, so I'm going to give it back to Peter, and he's going to talk more about the customer relationships side of things, since this has been more about the consent side of things.
Yes, thank you. Just to add one point, I just saw, of course, in our basic example email, there was a legal imprint fully in there, but we just shortened it for you to better see it. So what do we have to collect for the documentation of an existing customer's relationship? Well, basically also the date and time when the product or services were purchased. So this is similar to the consent version. But here we also need the point of sale. So this could also be, again, like a source, like a URL or of the shop, or basically the website of the shop. And could also be like the location of a store, like really if someone goes in there and gives buys something there and gives their email address for some reason. So the next thing would be which products have been purchased. So in order to prove the similarity, because the exception only allows emails for similar products to the ones that have been bought, it's necessary to prove or show what products have been purchased in the first place. And lastly, the information about the about notice. So it is necessary to was included when the customer's address was collected for the first time. So for example, in the shop, so it will tell me when I buy something here, you can cancel this or withdraw from this at any time. And of course, that proof was included in every following email. Regarding these points in detail, you will hear from us in the next webinars about this. But these will be the main 4 points that need to be proven. So the next point, we are regularly asked and see during the complaints process is the question of how long the data has to be retained. The short answer is you have to keep the data as long as advertising emails are sent, and someone could ask you to show some proof why you sent that. So there are cases where we heard that the complainant or user already demanded the removal of all their data. If the data subject demands the deletion of their data, of course they have the right to that, but that right can also be rejected in cases of the establishment, exercise, or defense of legal claims, for example. You can see that in Article 17, paragraph 3 of the GDPR, which states that the exceptions for the obligation to remove data are, for example, the defense of legal claims. So if a legal dispute is pending, so if you have already been sued by someone, or if a legal dispute is an abstract possibility, then you of course may retain that data to prove that your sending or your email was legitimate. Some legal scholars say that it is required that the legal dispute is more than a possibility and it should not be too abstract. That is, well, something for the academics basically, but the sender can also claim Article 17, paragraph 3b of the GDPR, which basically allows them to keep permission data if they are obliged to prove that by the law. And as shown before, the GDPR and other legal frameworks require the ability to prove the permission. So of course, no other data may be kept, just information that is necessary for the permission, but the permission data, like we just showed you before, can of course be kept. So to come back to the question, how long do you have to keep it? Well, as the lawyers and attorney love to say, it depends. And in Germany, we always recommend the period of limitation, which is in Germany, for example, it's 3 years. So if you send me an email today, you have to keep the permission data for 3 years, since I could sue you for the next 3 years. And if you send me another one in 2 weeks, you have to keep the data 2 weeks longer. And I think I will hand over to Sebastian for more stuff.
I'm sorry, it seems I was muted. So sorry about that. Thanks, Maike, for pointing that out. Again, I'm gonna put like to the question again. What are the effects of good documentation? So we've just learned how to document and what to document and for how long. And if you go through that checklist and make sure you check all the marks and see all the points, then this setting up of the documentation might act as a compliance check, actually, which is nice, because if you don't have proper consent things set up, then you can't document them, and then it would show up in the setup of your documentation. All right, so another good effect of that is, of course, avoiding complaints, especially with the CSA. And I know this is the most important point. This is why it's up there, even much more important than the fines. So you don't want to get in trouble with us, which is why avoiding complaints is a good effect of documentation. Then the second point, of course, is the fines. We've talked about those. Probably by now that Article 7 of the GDPR says that there can be fines up to 20 million euros or 4% of a company's total annual turnover, whichever is higher. And you've all probably heard the example of Google, who had to pay, I think, 50 million euros in France around 2 years ago, if I remember correctly. But that was more to quite broad data protection concerns, if I'm not mistaken. So let me take you to some examples of email marketing, because that is what we're all talking about here today. For example, not long ago in Australia, I guess you would know the company Woolworths. They had to pay just over $1 million US dollars for sending emails without consent, and even after customers had complained and or unsubscribed from those emails. So that is something that is very real, even just for sending emails. And this is where we have our second, let's say, interactive game. Gamescom has just closed this weekend, so we're going to do some gaming here. You can guess for the following case. We've prepared this case in Germany. So in Bavaria, there's a health insurance company that had to pay a fine because they sent emails without consent to, let's say, around 500 people. How much do you think was that fine? So I think the poll is open, if I see that correctly, and I would ask you to please try and guess how much did they have to pay. It's just 500 people, not, you know how big your lists are and how big they can get. I'm gonna give it a second until people have clicked. I know it's a lot of work. All right, results are in.
Results are in, yes. So the majority goes for 250,000 euros. I just here we can see it. Just
there we go.
Give me a second. Okay, so the majority is going for the 250,000 euros. 70% thinking that's the right number, and the other ones are just half going for the 12,000 euros and the 1.2 million. So Sebastian, it's up to you.
Well, 70%, that's pretty clear, though I'm sorry, but you're wrong. The health insurance company had to pay 1.2 million euros, which is, I think, quite interesting, because it's just, you could say, just 500 people that they emailed, and they are a health insurance company, which, technically is not, at least in Germany, not supposed to make a lot of money, not a commercial company per se, but still, apparently, the Data Protection Authority used whichever framework to put a number to that, and the number was quite high. All right, and last but not least, we have the point of maintaining a good reputation, which comes with documentation, because this is more of a soft point, of course, but you don't want to be on any blacklist just because there's a lot of complaints. Complaints being a point of its own on this slide, but still, this is still an effect of doing the proper legal work, and a big part of that is documentation, as we've seen. All right, so that's so far is closing the content part of this. So I'm handing back to our lovely host, and thank you.
Okay, thanks, Sebastian. Thanks, Peter, for your presentation. We already received some questions. Before starting to answer them, I'd like to encourage everybody to raise any further questions, so you get the information you want to have from us. I'm starting with the questions we already received. Give me a second. So the first one is not really related to the stuff we presented, but just the question if the slides will be available later on for the attendees. I think we have to discuss this also with Astrid, because not here in the call and cannot give a yes or no sign to me. If possible, and if she agrees, of course, you can have the presentation afterwards. So that was more an organizational question. Coming to the other ones, more content related. The second question is, how could the sender really prove that the double opt-in email was given and not simply made up? Shouldn't there be some service signing a customer's consent? So I don't know who of you is willing to answer this. Peter, Sebastian, who wants first? Any volunteers?
Probably no one. Well, of course, it's a difficult thing. There are ideas of doing it really proven and then safe, and at the third party, for example, to do your double opt-in via third party. But of course, you basically can just send the email to the customer. You have your sent mails. You have the log. You can also have the log of the double opt-in click. And at the moment, as a lawyer, and I put that very in highlights here as an attorney, that's the only technical solution I know.
Okay, next question is, are you verifying with the complainer that the source of consent is real? Would be interesting to have such feedback if you have it.
Sorry, that the source of the who's real? What?
Source of the consent. So I guess the question is, do we just feedback to the complainant when we receive the answer of the CSA sender and ask them for feedback on the data that's provided, and also it was website A or website B where the consent was given?
Sorry. I'm not sure if I understood the question correct, but we basically, if someone complains and we receive data from the sender, we forward that to the complainant and tell them this is what was told to us, and then we basically give them the option to give their statement. They can say, yes, I signed up there, or I signed up there, or I bought something but I didn't want emails, or yes, I signed up there but I clicked unsubscribe very hard 3 times, and then all this stuff. So yes, the complainer receives all the data we receive. So basically they get the information of is the source real, or where was it apparently obtained. And of course we also receive, sadly, very often the answer of, well, I've never been visited to that website and have never heard of that. So, but it's always a he said, she said.
Which is usually, sorry to interrupt, but which is usually a problem if there's no proof of double opt-in. We usually, those are the cases where we just get, yes, this complainant has signed up on this and that website. The complainant says, I've never been to that website. And then we have the problem of the burden of proof. He said, she said, as maybe not the right image that we want to put in here, but party A says, party B says, and these types of situations are always a problem for the one who is actually on this, on whom the burden of proof lies, and in this case, it's the sender. I hope we answered the question there.
I wanted to add that too. Yeah, I hope it's answered. Otherwise, please put it again in there.
Okay, next question. Hi, can I resend the email of double opt-in maybe after 1 day? Is it considered an unsolicited email?
Okay, that's actually quite a difficult question. I think we have the policy that 1 double opt-in is basically should be enough, because the recipient got it, and then if you start I say allowing question mark, but to send it several times, then the question is, where does it stop? After 10 times, after 15 times? And apparently if someone wanted a newsletter and they didn't click it, well, perhaps they changed their mind, and if they really wanted it, they will come back and sign up for it again. So I would say leave it at 1 double opt-in. I don't know if there were court decisions about that topic. I would have to look that up. I have something in my mind that there was something, but in a sense, also double opt-in can of course be a burden to the recipient if they receive it several times and they don't want that.
I mean, you could kind of compare it to the case where I sign up your email for a newsletter, you receive the double opt-in email, you didn't want that. That is technically unsolicited, but it's okay since it's the technical check of whether you signed up yourself, which you didn't. So that is basically an exemption where an email can be sent without consent, not with commercial content, of course, but you know, in the technical sense. 24 hours later, that would make even less sense if it wasn't you signing up, if I signed you up. So I would be very careful with that at the very least.
Just another note on the topic. Personally, there's basically the same thing with the reminder that your card that if you were going shopping somewhere and then you get the reminder, well, you haven't finished your purchase. That's basically the same. I actually stopped buying stuff at a certain store because they kept reminding me 3 times that I didn't finish my purchase. Yes, and I won't do that again.
Okay, coming to the next 2 questions, which belong to each other, I guess. So the questions would be, GDPR also states that personal data needs to be processed and transmitted securely. Practically, this means transmitting emails encrypted. How long do I have to keep records of the encryption protocol? So any volunteers on this question?
My first reaction would be that, you know, you keep the data to be able to prove that you had consent when you sent the email. So we've talked about the amount of time that you need to keep that. If the information about the encryption is needed to, you know, decrypt this proof information, it would need to be kept just as long, just for the same amount of time, is my first reaction without deeper legal thinking into this.
I would second that. If it's necessary to prove it, then you will need to prove it.
It's like I would put the proof in a box and then throw away the key. So I need to, you know, keep the key as long as I need to keep the things in the box. Please correct me if I don't understand the technical side of what you're asking correctly.
Okay, next question is, in case of OfflineCollect, is it okay to send a double opt-in email several weeks, months after?
So yeah, that's offline and double opt-in is a big question. As we talked before, Sebastian said very well that he would always recommend to have, and at the offline stages, some iPad or other tablet to have people sign up on the website directly, because how do you do the double opt-in at an offline thing? So do you have like a list and people write in that by hand, and then if you take it over to the computer, you misspelled it or couldn't read something? So it's always like an issue and then flawed, and you never know if I write my email or his, because it would be fun. So time isn't, well, the question was if it is offline, and then you could also ask that if I request a newsletter now and then 7 weeks later I get the double opt-in. Well, I don't have any court decisions about that. I know that there was in the past decision that said if you didn't use an email address for, then there was a lot of decisions about half a year up to 2 years or longer, then the recipient doesn't really, well, what am I looking for the word, nicht mehr erwarten, nicht mehr damit rechnen.
They don't expect to get any email anymore.
So then the question would be if it's still valid, but that was basically overthrown in another decision. So I don't know if I wouldn't say it's okay, but I wouldn't say it's not okay. I mean, 7 weeks later, I wouldn't remember signing up for a newsletter, so I probably wouldn't.
I would suggest it's kind of, you know, you can put parallels to the DOI email of an online process, because like if you sign up somewhere online, you don't expect the DOI email to come a week later. You expect it to come right then and there, or maybe 10 minutes later. I don't know, you know, but you wouldn't even wait for an hour for a DOI email. That would be weird getting that. And I would say it's, you know, with the offline world, it would come to yes, that can take a little longer because you need, as Peter said, the written list, you have to put that into some sort of digitalized system to even send a DOI email. And in that case, it can take a little longer. But a little longer, what does that mean? A couple of hours, a day, a week? I would say at least after 2 weeks or something, that would be too late, because that's not really in in connection anymore to the point in time when you actually collected the email address. But this is just me saying numbers. I'm not, as Peter said, I'm not aware of any.
I would even go shorter. Like
no,
2 weeks
yeah,
is a long time for the internet and email.
Which is why I said, a maximum, a time that would definitely be too high. I would go a lot shorter, actually, maybe a couple of days tops. Like say you're at a trade fair, say you're at the CSA summit, you get someone's email address, and then the summit takes a couple of days. You're not on your computer the whole time, and then afterwards you drive home. You're very happy because you've just been to the CSA summit, and you enter all these emails in your CRM, and then send out your double opt-in emails. I would say that would still be within an okay time frame. But what does a couple of days mean? You can interpret it.
I think that's a good example. Yeah, thank you for that question.
Okay, next question. What about content or text shown within registration or sign-up processes prior to sending a double opt-in message, and texts and privacy policies shown on confirmation landing pages? Do we need to have an audit trail, proof of evidence for such information as well?
So if I understand correctly, we're talking about information that is not necessarily connected to the consent, the email marketing consent, but things like terms and services, the terms of service, sorry, and data protection rules, things that you usually click. If I understand the question correctly, and as generally speaking, that needs to be documented, maybe not from a data protection standpoint, but please correct me, but definitely worth documenting, because all of that might be something that is in relation to the contract you're just signing. I mean, if you have a customer relationship, then there's a contract between you and the customer, and terms of service are an important part, or are at least part of that contract. So in that case, definitely, when just giving consent, I don't think so, because when people give consent, then everything that is important to that permission for email sending, then everything that's important is already in that consent declaration, and already, as we said, needs to be documented. And that's not everything in the data protection and terms of service dialogues that usually are huge texts and things that are not necessarily important for that specific thing.
Yeah, I just can basically add to that. I agree. And in regards of if it's just side stuff like how the website looked and so on, okay. But other than that, the GDPR basically states that to minimize the data you keep, so just the stuff you really need. So keep it small.
Okay, the next question is, hi, what if provider is not storing opt-ins and that is maintained by end user? In case of complaints, who is responsible to provide opt-in data to CSA? I assume by end user, the customer of the ESP is meant. If I'm wrong, Anton, would you please correct this?
So as a sender, you have the burden of proof, to make it very simple and blunt, and you have to have some contract or agreement with your clients that you can, of course, even if the not only the CSA but also the complainant addresses you have to be able to answer to that. And if that's not possible, or your client doesn't give you that data, I would recommend to leave that client to make it short, because you have to be able to prove that. Otherwise, you are also liable, if I understood the question correctly.
Especially, of course, in relation to the CSA and the CSA Complaints Office, which, you know, is the more important authority right here.
I assume the question is answered sufficiently because we got a smiley here and clear. So next question is, my understanding about a single opt-in resulting from a sale is that the customer has to check a checkbox during the checkout process. What kind of record in this case would be considered sufficient to prove the customer did check this box?
Didn't you? Were the double opt-in guy? Well, single opt-in is a, well, I think Sebastian, no, I don't remember who said it, but basically the courts at this moment or at this stage only accept double opt-in as some kind of proof. So single opt-in is not the proof, if I understand that correctly. And then the question will be finished for me. I'm sorry.
Yeah. I mean, we won't go too much into detail here about what you described basically is an opt-in that is done while actually constituting a customer relationship, and there's some pitfalls that, so stay tuned for next week. We're going to talk about that next week. But as for the actual documentation of that step, the same things that we said about everything today applies to that, of course, just as well. I guess Peter is absolutely right in that a double opt-in email sent after this would be the best proof I can think of. Otherwise, you have logs, you have things like that. I mean, this, you know better than I do the technical possibilities of these documentations. But as we've seen from the court decisions that we have seen about this, they usually say if you don't do double opt-in, you don't really document.
Yeah, you actually don't, well, you can't document any. Well, if I go on a website and I have the single opt-in, so you could have the IP in my technical understanding, but that could be from a VPN. It doesn't mean that the IP could be from not a single household or something. So you basically don't have a proof if it's right from that person. If it, yeah. So in short, do the double opt-in. Sorry, it's the only way at the moment. Or if there's another way to find that then, but single opt-in, you don't have the data points to prove that the person who clicked is the one who has the email address or is the owner of the email address.
Okay, thank you. So thanks for the participation, for raising your questions. Thanks again to Peter and Sebastian for the presentations and answering the upcoming questions. I really like to thank you also for taking part in our little surveys. So
I'm sorry, Alex, it's kind of frozen.
we hope you enjoyed this session.
There she is.
Two more things for today. The first thing is, here we go. Now it's better? Okay, I get a sign. You can hear me now. Thanks again for your participation and being very active. Thanks to Peter and Sebastian for their presentations and answering the questions. There are two more things for today. The first thing is we would be very happy to get your feedback. So at the end of the webinar, you will see a little survey. Please answer it or answer the email you receive tomorrow. That's the first thing. The second thing is we hope to see you next week, same day, same time for the second part of our legal webinar. If you haven't registered yet, please feel free to do so immediately. So thanks again and see you. Bye.